Differences between doctrinal legal research and non-doctrinal legal research. Doctrinal legal research versus non-doctrinal legal research. Doctrinal legal research is concerned with the analysis of the legal doctrine and how it was developed and applied by focusing on legal principle generated by the courts and the legislature. Doctrinal or library-based research is the most common methodology used by those undertaking research in law. Whereas, non-doctrinal research, also known as social legal research, is research that employs methods taken from other disciplines to generate empirical data that answers research questions. It can be a problem, policy, or a reform of the existing law. The origin of doctrinal legal research comes from the analytical or positivist school of thought. Whereas, the origin of non-doctrinal research comes from the realist school of thought. The aim of this doctrinal legal research is to make specific inquiries in order to identify specific pieces of information. Whereas, the aim of this non-doctrinal legal research is to study the real-world effects of legal process, society, and institutions. The scope of doctrinal legal research is legal research narrower as compared to non-doctrinal legal research, which deals with law in isolation. Whereas, the scope of non-doctrinal is much wider as compared to doctrinal legal research, as it gives a detailed and comprehensive understanding of law. Doctrinal legal research is used by the advocates for framing legal arguments and policy recommendations. Whereas, non-doctrinal legal research is used by advocates in forming policy decisions for social and legal reforms. Doctrinal research work is based on secondary sources of data, which include textbooks, legal articles, commentaries, and others. Whereas, non-doctrinal legal research is based on primary sources of data, which include surveys, interviews, and case studies. The type of research in doctrinal legal research is based on library-based theoretical research. Whereas, the type of research in non-doctrinal legal research is field-based socio-legal research. Doctrinal legal research is mainly concerned with legal propositions. Whereas, non-doctrinal legal research is mostly concerned with social values and individuals. In doctrinal legal research, it is not required to collect first-hand information. Whereas, non-doctrinal legal research requires the collection of first-hand information for case studies. Doctrinal legal research deals with legal doctrines and principles. Whereas, non-doctrinal legal research deals on focusing on the practical impact of the law on society. In doctrinal research, the research is mainly dependent on traditional or conventional sources of data. Whereas, in non-doctrinal research, the research is not solely dependent on traditional sources but also includes current problems at hand. A researcher doing doctrinal legal research only answers questions about one or two legal propositions. Whereas, a researcher doing non-doctrinal legal research answers more questions as it involves large areas of research work. Doctrinal legal research is less time-consuming and less expensive method. Whereas, non-doctrinal legal research is a more time-consuming and more expensive method. The basic sources of the doctrinal research are taken from established sources like legal norms and principles. Whereas, the basic sources of non-doctrinal research incorporates interdisciplinary perspectives and empirical data to provide a significant understanding of the law's impact on society. Special training is not required for doing doctrinal research. Whereas, non-doctrinal research needs special training, a conceptual framework, particular skills, and knowledge of other disciplines. In short, doctrinal legal research is concerned with methodically finding, examining, explaining and justifying the enacted legal framework. Whereas, non-doctrinal legal research is based on practical facts. It is fact-oriented research. Kindly subscribe my YouTube channel Thesis Helper. Thanks for watching.